going to go to part 2. And this isn't necessarily related to transactions, but it does impact some of the concepts that we're going to talk about. Let me just wait a moment for the train to pass. So avoiding IP infringement. We've talked a bit about this in earlier presentations. We're going to do a little bit more of a deeper dive just so you can get a sense of some of the risk and what to look at here. But the question is, you develop a product and are close to market release. You have not conducted a patent search to assess your risk of infringement. Well, what do? Well, as we've said before, the task at hand is really to conduct a freedom to operate study. And what is that? It's a search of relevant issued patents to determine if you have a risk of infringing those patents or any patents that are out there. Very important concept to understand in the freedom to operate study. This compares your commercial product to the relevant patents. It's not a comparison of your own IP to somebody else's IP. It's all about what you're commercially doing. What are you going to ship to your customers and receive money for? That's what we want to compare to patents, or that's what we want to assess for copyright infringement. That's what we want to assess to some extent for trademark infringement. It's really a commercial analysis and ought to be done at some point before market release, depending on the size and scope of your business. Why do we do this? I like to say there's really 2 reasons, maybe 3. I've listed 3 here. You as business people, you want to know if the products that you're offering is infringing another's patent. I haven't met many clients who actively really enjoy infringing third-party patent rights. Generally, people want to do something that's unique and set apart from others. And one way to do that is to avoid other people's IP. Number 2, it's a legal tool that limits your damages in case A, you're sued, 2, you lose on infringement, you lose on validity, and there's a damage award. I can then take this freedom to operate opinion and present it to the judge and say, look, judge, don't triple my damages. I reasonably relied on counsel that we had a non-infringement position. Don't triple my damages, please. So that's also what the freedom to operate study does. That is a real exposure minimization strategy. So if you're looking at a damage award of $1 million and it could be tripled, the freedom to operate study just saved you $2 million. Now, not to be discounted in litigation environment, but there is some practical use for it. If you're a startup and you are looking for capital and want to secure capital or investment, investors want to know, is there freedom to operate? Investors don't generally want to purchase a patent infringement lawsuit. Now, we'll talk about how you might address that situation in a due diligence context, or how you're going to, in the context of closing an investment. There's ways around addressing that risk, but generally you want to make an investment that is low risk, and patent infringement presents risks. Okay, so assessing freedom to operate helps you answer that. You've seen this chart before. You don't need to copy this down. We'll give these slides to you, but this is generally the flow chart of a freedom to operate analysis. Number 1, what patents are relevant? Just do a patent search of it. Phase 2, are there some patents that are kind of close that we have to look at a little bit closer and say, you know what, we need to really do a thoughtful comparison of the commercial product to the claims as they may be interpreted in court. Okay. Now let's say, does the product infringe the patents found in phase 1? If the answer to that is no, well then there's low patent risk. You have freedom to operate. What if it's yes? They're really broad and your product is covered by those patents. Well, you keep going because you're not required to compensate a patent owner if their patent's invalid. So we assess validity and we look, is the patent valid? Well, if it's not, for some reason, there's low patent risk. You have freedom to operate. What if it is? Okay, then you have 2 options before you really. is you secure a license so that you can function in your marketing and development, or you proceed in the face of risk. I have clients that do both, okay? Sometimes the patent owner, maybe they're not concerned about their litigiousness, okay? If the patent owner is Apple, it's a little different than perhaps somebody that has never filed suit for patent infringement before. I'm not saying that's a basis not to address patent risk, but it's a factor that you get to when you're at this point in this analysis. Just how do you assess it? Yes?
I'm not sure whether it's true, but I hear a lot of people, they get the patent, but they never commercially bring it to do anything with it.
Yeah.
Because if you find a patent, if you're infringing on another patent, what's the chance of buying that person's patent?
That's another option. I should add this to secure license, proceed in the face of risk, or purchase the patents. There's no prohibition of doing that, and that is something that happens, quite often. Let me just repeat the question, and I think I'll, get it right. Rich asked if you could just purchase the patent to address the risk, basically, and that's an entirely, reasonable alternative, and does happen, quite often. Let's do a little bit more of a deep dive into what I mean by comparing a commercial product to the patent claims. You've looked at we've seen a variation of this in earlier talks, but let's say claim 1 of the patent is a device, and this is required elements of the claim: a brown widget, a gray gizmo, an actuator, and a controller. Okay? You come to me with product A. It says, look, Greg, we see this patent, we're about to release this, or we're about to invest a couple of $1 million in raw materials to help manufacture the products. We just want to know what our risk position is. Do we infringe? Well, your product A includes a brown widget, a gray gizmo, a first actuator, and a second actuator, and a controller. Close, but there's some differences. Well, product A still infringes, okay, from just a literal infringement standpoint. You don't have freedom to operate there. You have a risk of patent infringement. And then at that point, you have a decision to make. Do we test the validity of it? Do you approach the company to secure a license or to possibly purchase the patent outright? All right, that's one option. The other option is maybe we can make a slight change that isn't detrimental to your product development plans and doesn't greatly impact just the product features that you have. So let's look at what that looks like. Product B, we do what we call a design around analysis. And you come back and say, look, I think I can change the color of the gizmo and it not be a big deal. My supplier can do that switch easy. It's not going to, if I have any regulatory issues, it's not going to present any regulatory issues. You don't have to change any product packaging. There's a whole number of reasons changing the gizmo is easy. Let's say we do that. Well, now we have a brown widget still, a black gizmo, a first actuator, a second actuator, a controller. Well, product B doesn't infringe the patent anymore because I have a black gizmo, not a gray gizmo. In some sense, avoiding patent infringement is that simple. It's easy for me to say, but then you as developers typically have to go find these design arounds. That's not always easy to do. But the point is, when you're faced with some patent infringement risk, you have options. It's not the end of the road, so to speak. You can change your product, you can get a license, you can purchase the patents, okay? Incidentally, what if we found out the black gizmo gives you some additional feature you didn't recognize beforehand? Well, that becomes a patent in and of itself. And really kind of an interesting patent to file, because now you're filing a patent application that will be publicly available. That is your design around analysis. Well, what are you doing there? You're creating your own little IP in that design around, so even third parties can't practice that change. Perhaps even the patent owner couldn't practice this change for the black gizmo, okay? So how does the that an FTO study impact top line, bottom line, and capital? Well, avoiding infringement certainly avoids unexpected costs. If you're not dealing with a patent infringement lawsuit or an unexpected royalty that you might have to rate based on your margins, your bottom line's being protected, okay? Designing around the patent and filing for new patent protection, really that does two things. You're still protecting what you're going to commercially implement. That helps you secure coverage and protect your market. That certainly should help maintain at least your top line. It may help your bottom line because you have a little bit different pricing power in that situation. I'll say it again, and I'll say it more in the presentation. Risk mitigation attracts capital. It does. Not necessarily having zero risk, but having faced a risk and have a reasonable plan to address it is as important as minimizing the risk itself, especially with early stage companies. Okay. Timing. When do you do the FTO study? Okay, there is the right time to do this. If it's very early stage conceptual work, that's probably too early. Okay, if in the example I gave you earlier, you're about to spend $500,000 on component parts, it's probably too late or just later than it should be. But there's this period between conception and where you have a completed manufacturing deck, you're ready to go. Sometime before that, but closer to commercialization. It should be at a point that you can adjust your product if you need to, okay? Where that is for each business is going to be different, okay? And there's no right point, but the idea here is to think about it at the conceptual stage, when you're conceiving the ideas, but certainly implement this at some point before you start attracting and generating revenue on your products.